All Hail Biafra! This is Biafra Liberation Army Network coming to you again. Please like, share, and comment.
So, for this morning, ladies and gentlemen, we're going to be looking at Nnamdi Kanu. Appeal court asked to set aside Abuja court ruling over grave legal errors. Once again, the title for this audio this morning is Nnamdi Kanu. Appeal court asked to set aside Abuja court ruling over, quote, grave legal errors, unquote. Appeal court asked to set aside Abuja court ruling over, quote, grave legal errors, unquote. Yes, and I think it's very important at this stage to, let our listeners know that a human rights lawyer, Mr. Christopher Chidera, has faulted the recent decisions of Justice James Kolawole Omotosho of the Federal High Court in Abuja, insisting that the ruling in the case against indigenous people of Biafra, IPOB leader Nnamdi Kanu, is riddled with inconsistencies and undermines the rule of law. Justice Omotosho had on Friday declared that Kanu has a case to answer on terrorism-related charges, despite what critics described as serious flaws in the prosecution's evidence. Reacting in a media statement, Chidera said the judgment, quote, departs sharply from established legal principles and underscores a troubling trend of prioritizing executive interest over justice in Nigeria's courts, unquote. The lawyer accused the judge of concentrating solely on the charge sheet while ignoring the weaknesses exposed in the prosecution's evidence during cross-examination. He noted that such an approach runs contrary to Supreme Court precedents, which require trial judges to determine whether prosecution witnesses have been discredited. Chidera also faulted the court for permitting charges to be pursued under the repealed Terrorism Prevention in bracket Amendment Act 2013. According to him, quote, prosecuting under a defunct statute is not a mere technicality. It renders the entire case a legal nullity. Section 122 of the Evidence Act 2011 obliges courts to take judicial notice of repealed laws, unquote. He argued further that the ruling contravenes Section 3611 of the 1999 Constitution, which protects citizens from self-incrimination by declaring that Kanu, quote, has a case to answer. Chidera said the court has effectively shifted the burden of proof from the state to the accused. Quote, collectively, these errors reveal a disturbing pattern. The judiciary in Abuja appears more committed to sustaining a politically motivated trial than upholding justice. Courts must serve as impartial arbiters, not as instruments of executive will, unquote, he maintained. Chidera urged the Court of Appeal to urgently revisit the judgment and correct what he called, quote, egregious legal errors, unquote. He also called on the Nigerian Bar Association, NBA, and the National Judicial Commission, NJC, to investigate recurring lapses in judicial procedures in the case. Beyond Nigeria, the lawyer appealed to the international community to closely monitor the proceedings, arguing that the government's handling of Kanu's trial violates obligations under the International Covenant on Civil and Political Rights, in bracket ICCPR, and the African Charter on Human and People's Rights. The ruling, critics say, raises fresh concerns about the impartiality of Nigeria's courts and the country's commitment to upholding fair trial standards. Ladies and gentlemen, that is in a nutshell, a synopsis of the trial or people's observation of the last trial of Mazi Nnamdi Kanu, where Justice James Omotosho of the Abuja High Court, insisted that the ruling, uh, ruling, that's the ruling. I mean, they insisted that his ruling on the case against indigenous people of Biafra, IPOB leader Nnamdi Kanu, is riddled with inconsistencies and undermines the rule of law. James's Justice James Omotosho had on Friday declared that Kanu has a case to answer on terrorism-related charges, despite what critics and everybody describe as serious flaws in the prosecution's evidence. Ladies and gentlemen, if a lot of you had listened to us in previous months and in previous weeks, we have told you how Justice James Omotosho allowed masked witnesses who came into the court to give evidence and evidences against Mazen Nnamdi Kanu. They were hooded, they had things in their mouth that made sure nobody recognized their voice. And when Justice James Omotosho was asked, why the hooded witnesses? Why are there masked people here? He said, of course, these are DSS operatives who work incognito, who should not be recognized, so that, of course, they are not supposed to be recognized because of, threats to their lives, possible threats to their lives and all that. Of course, the whole world was astonished because it was about the first time that this kind of mass witnesses came up in such a high brow case. It was totally against judicial, practices in advanced climes. And so Justice James Omotosho originally, who said Mazen Nnamdi Kanu had suffered so much in detention, James Omotosho, who said, I feel for you, Mazen Nnamdi Kanu. I think your case should have been ended by now. And equally the same Justice James Kolawole Omotosho, who said, Nnamdi Kanu, I'm with you all the way. I'm going to make sure your case does not linger any further. I mean, Justice James Kolawole Omotosho said all this in the full glare of journalists, of court attendants, of people, of the mass media, and these statements and these postulations were fully and vigorously spread around the mass media. It's unfortunate that the same Justice James Kolawole Omotosho could allow hooded witnesses that turned his high court premises and high court at Abuja to a gangster's paradise. I mean, we know it's gangsters who wear masks. We know it's gangsters who wear hoods. It's gangsters who try to hide their voices to sound differently and to sound like they are not the ones. So it's very unfortunate. These same witnesses, these same people who were hooded up, who were masked up, were allowed to come and give disparaging, totally false, and many times exaggerated evidences against Mazen Nnamdi Kanu. And so on Friday, penultimate Friday, the 26th of September 2025, when the resumption of Mazen Nnamdi Kanu's case at High Court 7 under the Justice Kolawole James Omotosho. The same James Omotosho came to say, yes, James Omotosho said on Friday he had declared that Kanu has a case to answer on terrorism-related charges, despite what critics describe as serious flaws in the prosecution's evidence. So, ladies and gentlemen, Barrister Chidera, yes, Christopher Chidera, a human rights activist, and a man who has followed continuously and endlessly, who has followed the persecution, the mistrial, the trial and mistrial, and all the, errors involved in the handling of, Mazen Nnamdi Kanu's case. He has come out to say, no, 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 this is not right. Mr. Christopher Chidera has faulted the recent decision of Justice James Kolawole Omotosho of the Federal High Court Abuja, insisting that the ruling in the case against indigenous people of Biafra IPOB leader Nnamdi Kanu is riddled with inconsistencies and undermines the rule of law. Reacting in a media statement, Christopher Chidera said, the judgment, quote, departs sharply from established legal principles and underscores a troubling trend of prioritizing executive interest over justice in Nigerian courts. The lawyer accused the judge of concentrating solely on the charge sheet while ignoring the weaknesses exposed in the prosecution's evidence during cross-examination. He noted that such an approach runs contrary to Supreme Court precedents, which require trial judges to determine whether prosecution witnesses have been discredited. Chidera also faulted the court for permitting charges to be pursued under the Repeal Terrorism Prevention Act 2013. According to him, prosecuting under a defunct statute is not a mere technicality. It renders the entire case a legal nullity. Section 122 of the Evidence Act 2011 obliges courts to take judicial notice of repealed laws. Yes, ladies and gentlemen, I think it's very glaring, totally clear. Yes, indeed, very clear that Justice James Kolawole Omotosho is dancing to the gallery. We said it here, and we encourage him to be sincere, to be just, fair, and magnanimous in his judgment, because we have noticed that back to back, all through the charges of Nnamdi Kanu, beginning from when the PMB was president, the late PMB, there has been an executive interest in his matter. What I mean is that it seems the government at the center has always determined, has always orchestrated, has always influenced judgments against him. And we had hoped that with Justice James Kolawole Omotosho coming on board after Justice Binta Nyako recused herself. Yes, you remember Justice Binta Moritala Nyako recused herself from the case after Mazen Nnamdi Kanu said and completely, bitterly told the whole world that he would not get fairness in Justice Binta Moritala Nyako's trial, because of course, but Justice Binta Moritala Nyako had showed eminent, obvious, and very conspicuous bias and prejudice against him, and she seems to be more interested in satisfying the junta, the cabal, the Jagaban, and his acolytes, satisfying them so that they can tamper justice, tamper mercy in the justice against her son and husband who are at the EFCC facility for trial. I mean, the husband, former governor of Damawa State, Vice Marshal Murotala Nyako, retired, has been, accused of several misdemeanors, financial, political, and economic, and is cooling in the EFCC coffers. Of course, Mazen Nnamdi Kanu, said bluntly, clearly that Justice Moritala Binta Nyako would have a prejudiced attention towards him because she wants to do everything possible to satisfy the junta. Fortunately, and accordingly, Justice Moritala Nyako, Binta Moritala Nyako, recused herself, and the case was once again thrown back to the Chief Justice of Nigeria. Ladies and gentlemen, the Chief Justice of Nigeria appointed Justice James Kolawole Omotosho to take over the case. And we thought when he came out, preaching good news, preaching, apologizing to Mazen Nnamdi Kanu for the long detention, when he came out saying, "You are a man like me. I know your family has suffered terribly. I know your business has suffered, terribly. I know your health has suffered